There was an issue with the plaintiff getting off of state assistance. He's continued to pay $2,300 a month, even though the agreement was to reduce it to $2,000 a month.
Single mom, single-handedly raising the child. The father has zero involvement.
I have never had an issue with the $2,000.
Matter of Masterson, now Andreessen versus Yardley, case number 1C. Mr. Hess, I've read your motion. Is there something that you'd like to add to it?
No, I think the issue is pretty simple. There's been a long delay since we reached this agreement through email, which I certainly think is binding under the court rule. MCR 2.507G. We had done lump sum payments in the past outside of the front of the court, but there was an issue with the plaintiff getting off of state assistance. And so we just really need this order entered. It's been just a long delay. So we're just asking that this order be entered.
And the longer the delay is, the more problematic it gets, because this order goes back to only May 1st of 2023. Yeah, if there's a 2-month arrearage, the federal reporting agencies reported on your credit rating, so it didn't get credit.
The problem is my client has actually paid the old amount through the front of the court. So he's continued to pay $2,300 a month, even though the agreement was to reduce it to $2,000 a month. So that's why in the UCSO, I put that he will pay $1,700 a month until his overpayment is corrected.
I think $1,700 a month is what the front of the court recommended after their investigation. So, Miss Forsyth, what is your...
All right, guys. Today we step into a tense courtroom where patience has officially run out. The issue, a child support modification that's been sitting unresolved for over a year. The father's attorney opens with frustration. Payments of $2,300 a month are still being made, even though an agreement to reduce them to $2,000 was reached months ago. Bureaucracy and missed signatures have turned this simple fix into a drawn-out legal maze. The judge's tone is sharp. This delay has real consequences, affecting credit reports, arrears, and compliance. It's not just about numbers. It's about trust in a system that moves too slowly for families who can't afford to wait.
Input on this. I didn't get a response.
Well, because I'm sitting in here with Ms. Andreasen as a professional courtesy. She has been represented by Connie Thacker until probably yesterday or the day before, when Connie withdrew. Ms. Andreasen intends to, if need be, retain Wade McConnell to represent her. But this is all, I'd asked Mr. Hess if he would adjourn the motion a couple weeks, but he won't.
This has been pending for over a year. Why would he adjourn?
Well,
we need an answer here, and he attached the emails. This is an agreement between parties.
Well, here again. I'm not. I haven't.
I know you're sitting in, but Ms. Forsyth, she may represent Wade McConnell, but I don't think I have a choice under the court rule. I've got evidence that this is the agreement. This was the agreement last April. It has now taken a year to get this in place, and it needs to be put in place. So I'm going to follow the agreement of the parties. I am going to grant the entry of this child support order just to move this along. If she would like to object to it using Wade McConnell, they'll have to explain to the judge why the court rules do not apply.
Yeah, no, I understand. I guess the one thing we would ask, and Cindy, please interject, because I obviously don't really know the background here. All I know is, I did speak with Cindy yesterday, and she has no issue with the $2,000 a month. She said she actually never even got that. She's fine with that. Her issue is, here we have the single mom single-handedly raising the child. The father has zero involvement. Our issue is just don't make her pay the money back.
As arguments unfold, the courtroom energy grows tight. The father's lawyer cites binding email agreements, official rules, and state assistance issues, while the opposing counsel hesitates, stepping in for a former attorney who just withdrew. The mother's new legal direction hasn't caught up with the case's speed. The judge, tired of stalling, makes it clear the court must follow the agreement made in writing. After a year of limbo, the ruling will be entered today. The law demands closure, not confusion. What we're watching isn't hostility, it's procedural fatigue. Justice delayed, as we see here, is still justice denied.
No, it's not being paid back. It's backdated, and that's why the child support is reduced until it's paid, until it comes to zero. If there's an arrearage, he would have had to pay it. If there's an overpayment, then it has to be, the child support is reduced, and it's only being reduced by $300 a month. And since he's agreeing to pay you almost $3,000 more than what the child support guidelines indicate, she's not coming off much worse for the wear.
Cindy, do you wanna throw in your 2 cents here? Because you obviously know the background here, and I don't.
Right.
You know, I completely agree with Dan Hess and that this can has been kicked down the road. I have never had an issue with the $2,000.
Okay.
I put something in writing in February stating, you know, to Connie's office, yes, I'm still on board. Let's proceed forward. I have no issues with this.
Okay.
A month later, she called me and said, okay, where are we at? And I said, my position hasn't changed. I'm aligned with the 2,000 per month.
Right.
We all agreed on that. And she said, are you receiving support at this time? I said, I am. In fact, I'm receiving $2,300 a month. And she said to me, my advice to you is to sit back and leave it if you're getting the $2,300 a month.
Well, and there's a consequence to that because he's overpaid.
Here, tension turns personal. The stand-in attorney tries to slow things down, asking for a short adjournment, but the judge refuses. The time for pauses has passed. Evidence shows clear written consent from both sides. The ruling must move forward. The courtroom feels the quiet weight of bureaucracy unraveling. For months, one mother waited for decisions tangled in paperwork and shifting representation. The court's voice cuts through it all. Rules exist for a reason, and agreements signed, even by email, carry legal force. What should have been handled in weeks took a year. Now, there's no turning back.
But yeah, and asking for the amount to be reduced by $300 until that amount is made up, then it will jump to because technically it's the 2,000. It's just lowered by a monthly amount until the offset is made to zero, and then it goes to the back. It's going to be at the 2,000.
Okay. So I'm completely aligned with the 2,000. Nothing from Attorney Thacker has ever been presented to me.
Okay.
Multiple emails I followed up with her to say, where are we at? Like, I feel like we're kicking the can here. So much so that, I mean, even last week, I got the motion sent to me out of the blue, and I said, why is there a motion? Like, who's fighting? I'm aligned. Let's go.
Yeah, so it's not a fight, and I'm going to agree with you, Paul. All I'm going to just enter this.
The one thing, referee, that I wanted to bring to attention, I'm in the process of negotiating a new job offer, which was the reason that I requested.
Your pay is irrelevant to this. Okay, to explain it mathematically, he is set at 0 overnights. What the guidelines do is they calculate how much you would pay him if he had full custody, and it calculates how much he would pay you if you had full custody.
As math meets emotion, we see the system's human cost. The father overpaid by months, totaling nearly $3,000 beyond what was required. The court decides he'll now pay $1,700 monthly until that balance evens out. The mother's counsel concedes, yes, she never had an issue with the $2,000 amount. She admits she's been receiving $12,300 all along and was told to just leave it. But there's a price to overpayment, and the judge lays it out plainly. Fairness cuts both ways. Behind the numbers, there's an uneasy truth. Cooperation without clarity always leads back to court.
Then it offsets using the parenting time.
Sure.
And normally 0 to 70 doesn't do much, or I should say 1 to 70 does very minimal changes because they don't want people arguing over every other weekend, sometime during the summer and every other holiday. But anything times 0 is 0. So there is no offset by your salary. Okay. I could cut your salary in half. I could double your salary. Anything, again, times 0 is it. So this is based 99.99% on his income only.
Okay, that makes sense. Child care expenses will be a large portion of this, which is why I was hoping to not waste the court's time now. And then once I have the job offer in place and I'm paying child care, she's 8 years old. Summer started last Friday. There's going to be
going to have to be reassessed due to daycare?
Yeah, the costs.
Okay.
I know. Well, I tried to call Attorney twice. I wrote a note to your clerk.
All right. So how daycare is calculated by the program will take how much you pay during a year, or how, so in other words, if you only pay for the 3 months of summer, it gets divided out by 12 months. So you may pay, let's say $300 a week for 8 weeks. That's $2,400. That's $200 a month.
Okay.
But it then also takes out your tax break on that. So if you get the full tax break, because you're not paying more than what the tax break used to be, what, $2,400 per child? So you might there may be no daycare, so you may want that calculated first. Okay.
Yeah.
And understand, like I said, the calculation said that he'd only pay $1,700. You throw daycare in there, and it throws out this agreement. So it may come into exactly where you're at. Talk to an attorney. All right, just in case. I'm just trying to help and explain. I'm trying to also explain to the attorneys, because sometimes the nuances, which I see frequently, they don't. So, and sometimes I have a lot of attorneys that are arguing over nickel and dimes.
I understand.
And you're getting more in attorney fees than you're going to pay than nickel and dimes that are going to occur to the changes. So make sure you know what you're asking for before you ask for it. Mr. Hess, I'm going to grant your order, and I'm going to set this in place. Okay.
All right. Thank you, Your Honor.
Thank you. And Ms. LeVay, I've got the UCSO here signed. I'll need my signature sheet for the back of it.
Do you need me to present you with anything further, Your Honor?
Nope. I think the UCSO modification is appropriate.
Okay. All right. Thank you, Your Honor.
All right. You take care. All right.
Yep, you too.
All right. Bye, guys. Have a good weekend. Take care.
Nice seeing everybody. Take care,
Andrea.
everybody. Okay. I'm confused. Like, if everybody was in agreement, why wasn't this signed a while ago?
The mother finally speaks for herself. Calm, articulate, but visibly tired, she confirms her side. She's been cooperative, transparent, aligned with the $2,000 agreement from the start. Her frustration isn't with money, it's with process. She recounts emails, phone calls, unanswered motions, months of silence. The judge listens closely. The courtroom tone softens for a moment. This isn't a battle of greed. It's a collision of patience and paperwork. For her, this delay wasn't just legal. It was emotional, a constant reminder of how hard single parenting becomes when the system drags its feet.